Good morning, good morning. Happy Akshay Triti day. I would like to discuss with you the young lawyers, criminal lawyers. First of all, I would like to draw your attention the provisions of 457 and 451 CRPC, then 452 CRPC, then 454 CRPC deals with the property seized by the police during the course of investigation, alleging that the property was involved in the crime. So you may be approached for return of that property, jewels, vehicle, or other valuables. First, you have before the trial court, the lower court, magistrate court. Even if the case is a trial by sessions, you can still file application before the lower court. First, if the property was seized and that information was given to magistrate, but the property if not produced, then you have to file an application under 457 and 451 CR. Direct the police to produce the property and to return the property pending investigation. Then the major concept for return of the property, your claim for return of property must be on few grounds. Number one, that you are the owner of the property with substantial evidence. Number two, that the property is returned to the petitioner. The subsequent possession may not be culpable one. Culpable means if the property is given to you, if you possess that property, that possession itself may not be punishable. If you want ganja to be returned, then subsequent possession of ganja would be culpable. Therefore, the other vehicle if returned to you, the subsequent possession may not be culpable. Another ground was that though the property was seized by the respondent police, and because since they are bound to return the property as it was seized on final stage of the trial, and since the respondent is not having sufficient space to keep the property being deteriorated by air and other natural things, therefore it is far better to return of the property to the petitioner. And all other grounds, substantial suit, all these things are. So then if suppose the property was not returned to you, there may be a rival claim, then the trial court at the time of conclusion of trial is directed under 452 CRPC to return the property to any person, either the owner or the property which was seized from the person. This is the 450. If the 452 was not considered by the court, you can file an application under section 452 CRPC for return of the property even after completion of the trial. If that was not done, or you can file under 454 CRPC an appeal against the final disposal cases return of property, not pending investigation. The return of property pending investigation is not granted to you. You have to go to High Court under 482 CRPC. Or if the final order seems to have been passed exhibiting that you are not at all entitled, that may be a final order, then you can file a revision against the order. These things are there. Then question arises, so far Prohibition Act, NDPS Acts are concerned, the executive authorities are empowered to confiscate the vehicle, confiscate the properties. Under Tamil Nadu Prohibition Act, Section 14(4) empowers the authorities, revenue authorities, on application by the state police for confiscating. But there should be a notice to the owner of the vehicle. And also there should be another opportunity at the time of passing order that in lieu of confiscation, the owner of the vehicle or owner of the property may be directed to compensate the cost for getting return of the property. This is the case. In this regard, one case law, this is 2022 one law weekly criminal 115. 2022 one law weekly criminal 115 Madras. Saravanan was the additional superintendent of police. Here actually what had happened, the police claims that notice was given, but actually they claim that the notice was served on 1/6/2017. But on record, the petitioner, owner of the vehicle, was detained under the Gundas Act, and he was in prison from 31/5/2007. Therefore, that was not given, and another appeal provision is there that was also not provided to him. And finally, the Honorable High Court says that the opportunity for substituting confiscation by payment of some amount, fine, whatever it may be, therefore, value of the vehicle, pay value of the option to pay value of the vehicle is not given. Therefore, the order of additional the revenue authority was set aside. This is Saravanan was additional superintendent of police 2022 1 law weekly criminal 115. So I hope you understand the concept of return of properties. And there is something more, how to get return of property of cash and how to defreeze the bank account. All those things are there. That has to be dealt separately. I hope you understand. Best wishes.